Ecuador's indigenous communities try to hold Chevron accountable, this time in a Canadian court. What will it take for the energy giant to pay out the billions of dollars it owes for the pollution of the Amazon? You're watching Inside Story Americas from Washington. Hello, I'm Shihab Ratansi. After decades of oil drilling, they've seen their land destroyed and their waters polluted. But members of Ecuador's indigenous communities have yet to see a single penny for the damage inflicted on their lives by Chevron and its subsidiary Texaco. Nearly 2 years ago, an Ecuadorian court found the oil giant liable for the pollution and ordered it to pay more than $18 billion to the plaintiffs. But Chevron, calling the case fraudulent, has sought to block enforcement of the ruling in the US and international courts. Since Chevron has few assets in Ecuador, the plaintiffs are trying to get the ruling enforced in other countries. 2 weeks ago, a judge in Argentina ordered the freezing of all of Chevron's assets in that country. They're now hoping for a similar ruling in Canada. So, can international courts enforce the Ecuadorian judge's ruling and finally succeed in holding Chevron accountable? To discuss this, we're joined from Toronto by Graham Arion. He is one of the attorneys representing the Ecuadorian communities. Here in the studio, we have Andrew Miller, advocacy coordinator with Amazon Watch, and Tyson Slocum, the director of Public Citizens Energy Program. We invited Chevron to participate in the discussion, but they were not able to provide a representative in time for the taping of this program, but we do look forward to having them on to discuss this issue in the future. Andrew, I suppose the easiest thing then perhaps is to start at the beginning with Texaco's drilling in this region. How much damage was caused over how much of an area, over how much time?
Yeah, I think when people think about oil spills, often what comes to mind is something like the Exxon Valdez or the recent oil spills in the U.S. Gulf Coast. This is a very different situation where over the course of decades, essentially, you had different kinds of pollution. And Texaco dreamt up, designed, and implemented this over the course of several decades in the 60s, 70s, and 80s. And there's a whole series of ways. And they essentially designed the system to pollute in order for them to save maybe $3 per barrel of oil.
So they knew they were doing this?
Well, they weren't up to international standards and standards that they would have had to use in the United States. For example, for the reinsertion of what we call produced waters, which is essentially the toxic waters that come out along with the oil. So that was just dumped directly into the Amazon River, there in northern Ecuador. They also created over 900 unlined toxic waste pits. They paved roads with toxic waste, they flared gas, and then the pipelines that they created were substandard and they ruptured. So essentially, the communities that are living in this area, which is roughly the size of Rhode Island, the state of Rhode Island in the northern Ecuadorian Amazon, the residents there had to live with this and continue to live with the legacy of this kind of infrastructure. And so what we've seen are, all kinds of different problems for the indigenous communities here. There are 5 different indigenous peoples that saw the loss of their territory, cultural impacts, but it's really the health impacts that we've been seeing, different kinds of cancer that have come about, and hundreds of people who've died from cancer.
How definitive have the studies been on the health impacts, though?
Maybe Graham can talk a little bit more about this, but essentially what happens is we were seeing different kinds of cancer that have come about that we're not seeing in other parts of the Amazon.
Graham, we'll get on to the specifics of the various legal cases later, but do you have specific scientific studies connecting the oil pollution to the sort of health?
Yeah, there's been a number of epidemiologists who traveled to the area beginning in the 1980s, and there's been a number of peer-reviewed studies in medical journals documenting the elevated cancer rates and showing the closer that families were in proximity to the oil wells, the higher rates of cancers. These studies obviously vary in the exact numbers, but the judgment cites at least 256 families, but other studies go as high as 1,500 people died directly out of cancer related to the contamination. But in addition to cancers, there was elevated levels of infant mortality. There is elevated issues, gastrointestinal issues, all the types of real public health crisis that you would see in an area that really has almost 1,000 Superfund sites in 1,500 square miles. I mean, the concentration of toxic waste is unprecedented.
Chevron did acknowledge health problems, but suggested it was more to do with poor sanitation and poverty. Is that correct?
Right, because yeah, I mean, this is the arrogance of an oil company that blames a lack of sanitation on cancer, yet there was never any sanitation there to begin with. And there certainly wasn't these elevated cancer levels and this public health crisis before the oil companies. And there's other areas in Ecuador that also lack sanitation that don't have these cancer levels. So that's, I mean, that is an argument that has not been supported by any peer-reviewed science.
Tyson, we're just going to pause the story there for a moment. Tyson, I mean, does any of this surprise you, this idea of shareholder value coming before health and environmental standards? Could something like this happen again, or is this something from the bad old days of the 60s, 70s?
Oh, no, I mean, we're seeing it today with a massive oil spill that is taking up 20 miles of coastline in Nigeria that is the result of a problem with Exxon. We see numerous examples anytime you've got a very powerful, deep-pocketed multinational oil company operating in countries that may not have the financial resources or the independent judiciary or public officials that might be prone to accepting bribes.
But specific memos saying that we probably should insulate these pits, but actually it's going to cost a bit too much. Let's not bother. I mean,
right. I mean, routinely, oil companies are operating in countries that might have substandard environmental regulations, or they might have environmental regulations that get unannounced waivers because of a deal struck between certain government officials and oil companies. And so this is clearly a problem. Every once in a while we see countries taking a strong stand. Brazil, for example, after the Chevron oil spill last year, has basically preliminarily thrown Chevron out of the country, out of the business of deep water drilling off the coast of Brazil. So every once in a while you see countries standing up, but that's not always the case.
We'll get back to the sort of the conflict that actually perhaps some of these countries have in whether to enforce their environmental standards or whether to actually, at the risk of scaring away international investment, perhaps a bit later on in the show. But let's get back to the story then. Chevron says that Texaco. Remember, Chevron bought Texaco in 2001. So this predates their ownership of Texaco. But they say, look, Texaco, it did everything it had to do. I mean, they do acknowledge the environmental damage, don't they, actually, First Century?
Well, they claim that there was a cleanup, a $40 million cleanup.
So there had to be something to clean up. So they've acknowledged, though, that
there had to be something to clean up, but if tests have been done on those sites and they maintain the same level, high levels of toxicity. And it was, even if the $40 million worth of cleanup would have been on point, it was woefully inadequate when you have 900 toxic waste pits, Superfund sites. But then
they said that they were only required to clean up a third of the sites as per its share of the consortium that was overall in charge of the drilling. So they had a third of the interest in the consortium, so therefore they only were responsible for a third of the cleanup. Yes, Graham.
Just on, I think that there's a very important legal point, and Andrew mentioned it before. It was Texaco that built and designed and operated the entire oil concession. So even though over time, the state-owned oil company Petroecuador took a larger share of that concession, at no time did Petroecuador ever make any decisions as to whether or not to line a pit or whether or not to report a spill or whether or not to properly deal with its toxic waste. And to go back to the point that was made earlier, about this being about money, we saw in the trial it was produced, a 1980 memo where the Ecuadorians, the Texaco, its subsidiary in Ecuador, sent a letter to headquarters in the United States saying, we're thinking we should maybe line these pits. And headquarters wrote back and said, well, actually, we've done the study. It's $4.5 million, and we think that that's cost prohibitive. So that's why we have this real epidemic of cancers and public impacts and indigenous cultures that have been decimated, really to save $4.5 million.
All right, Graham, so then the lawsuit is filed then in the early 90s, but then it's moved to Ecuador at the urging of Chevron. Perhaps you can just quickly, in a nutshell, explain that chain of events.
Yes, well, at the time, the rainforest communities in Ecuador, they saw that their government had been really cooperating and in cahoots with the oil industry, and they didn't trust that they could get a fair trial out of Ecuador. So they filed the case in New York, which was at the time the headquarters of Texaco. And Texaco really fought for 8 years to have the case moved to Ecuador and said that Ecuador was the more appropriate jurisdiction, and they promised that they could get a fair trial there. And they actually submitted 14 affidavits from experts saying how great the Ecuadorian judiciary was. And finally, they convinced the court in the United States that they would submit to Ecuador's jurisdiction and waive the statute of limitations and abide by any judgment out of Ecuador. And by the time they did that, they had actually merged with Chevron. So it was Chevron Texaco who made that promise in 2002, and then the case was refiled in Ecuador in 2003.
So that then, I mean, again, we're zipping through this just because unfortunately we have to. So now we have this ruling then, February of this year then.
February of last year.
February of last year, I'm sorry.
Yeah.
Initially...
2011.
2011. Initially, what was it, about 18 billion, now it's somewhere about 19 billion, is that?
18.2 billion, yes.
Right. And the judge, I mean, how did he come to that conclusion? What did he say exactly? I don't know which one of you wants to summarize that.
Well, I can just really briefly. I mean, you know, that isn't money that just goes to the communities.
Right.
You know, it's not like they're just all going to be multi-millionaires there, the 30,000 plaintiffs. I mean, those are funds that go towards different kinds of bioremediation of the soils, water cleanup, and healthcare costs. You know, so that's, you know, really kind of the minimum that's necessary in order to deal with the epidemic that Graham has been talking about. So it's important to be clear about that these aren't, you know, I mean, I think, you know, one of the kind of fictions that Chevron has tried to perpetrate is this, you know, kind of notion of, you know, this is all about greed essentially, and people are going to Chevron because that's where the money is. I mean, these communities are facing real problems, and this is an attempt to actually deal directly with those problems and not just make a bunch of money for the individuals.
Well, I think you suggested then some of Chevron's response there. First of all, actually then, Graham, having made that case that Ecuador was the place to have this case heard, they argued, in fact, it wasn't the place to have it heard because it was all corrupt.
Well, of course. As soon as the case was refiled there, less than a year after they promised to submit to the jurisdiction of Ecuadorian courts, the first argument that Chevron made in Ecuador is that the Ecuadorian court didn't have jurisdiction over them. I mean, the reality is this company didn't want this case heard anywhere, and that's solely because the facts are so overwhelmingly against them. This trial went on, it was still litigated for another 8 years in Ecuador, and produced one of the largest evidentiary records of any trial in civil litigation history. I mean, the trial record is 216,000 pages. Chevron submitted over 50,000 chemical samples. There was 104 separate expert reports. I mean, the trial court reached this conclusion on such a preponderance of evidence that's why Chevron has had to attack the court itself. It's begun to attack the plaintiffs. It's begun to attack everybody.
Right.
But what it can't attack is the fact that the evidence was against it because it admitted to doing this.
But that is, though, currently, though, where things stand, though, the main plank, the main strategy of Chevron right now is to suggest that they are the victims of an enormous extortion scheme, basically, a racketeering scheme.
Right. We somehow came up with 62,000 chemical samples that were fraudulent.
And you know, Chevron, I think, is facing sort of a Karl Rove moment. I mean, everyone, you know, remembers Karl Rove during the election recently, you know, kind of confused and befuddled in the kind of cognitive dissonance that was going on around what was happening in Ohio. You know, Chevron's claim has been that, you know, no court system around the world that respects the rule of law will actually, you know, carry out this enforcement. And what we're starting to see is that court systems around the world that do respect the rule of law are actually ruling in favor of the plaintiffs.
But they do say they have evidence, partly actually outtakes from a documentary about the case they accrued, where apparently they said, you know, there was lots of banter basically about, you know, how, you know, the sort of tactics being used by the lead lawyer on the case on behalf of the plaintiffs. Also that the independent experts report might have been written by the lawyers and so forth. What do you make of what about those charges, though, Graham?
Yeah, I can speak to that. I mean, Chevron basically took 600 hours of outtakes, and with, you know, they had 500 lawyers working on this case in 6 PR firms, and they whittled that down to about 6 minutes of quotes taken completely out of context, and have put these towards the Ecuadorian court, the Ecuadorian appeal court, and the courts have found that they're actually baseless. But more to the point about this one individual expert, which they said that the plaintiffs cooperated with him, they paid him. Well, in fact, we did do that because the court ordered both parties to cooperate with this expert who was doing a damage assessment. And the rules of civil procedure in Ecuador is, because this is a poor country and the court system doesn't have a lot of money, both sides are supposed to pay that expert's fees. Well, Chevron boycotted that process, meaning that we were the only side that could work with him, and we were the only side that could pay his fees. But at the end of the day, the judge looked at all of this. Chevron put all these accusations in, and the judge said, okay, I have 104 expert reports. I don't need this one. This particular expert report that you have a problem with, I'm not going to base any of my ruling on. Completely excluded it from the record, and still found this company completely liable for over $18 billion worth of damages.
Tyson Slocum, I mean, how important was this ruling? And indeed, how characteristic then is the response of Chevron then to try and belittle the entire system that produced that ruling?
The ruling was very, very important because as we see in a fully developed country like the United States, when there's a big oil spill, like with BP's Deepwater Horizon, the company put forward a voluntary $20 billion payment because they knew that the transparency and legal systems and enforcement actions of a country like the United States, even though they can be weak from time to time, were going to force the company to do the right thing to make sure that victims were going to have resources to be compensated. When you're dealing with a country that lacks some of those resources, the knee-jerk reaction of large corporations is don't do anything to compensate people. Get by for as cheaply and as quickly as you can. And so that helps us understand why Chevron is taking such an aggressive stance here, because they do have a lot to lose. And it's important to set a precedent that these types of crimes and this type of pollution, that companies have to be held accountable.
Interestingly, another tactic used by Chevron was to lobby the U.S. government in 2008 to withhold trade preferences for Ecuador, Tyson. Again, that's that dilemma that must be in the mind.
Sorry, they've actually done that every year since 2008. Just to correct you, the Ecuadorian, this is the Andean Trade Preference Act, which Ecuador gets free trade for in a sort of a quid pro quo to spend a lot of money fighting drug trafficking. And every year that has to be renewed. And every year since 2008, Chevron has lobbied very hard in the U.S. government with some very high-powered lobbyists to cancel those trade preferences, to try to punish Ecuador. I mean, this is what happens when you lose a case on the evidence.
Right.
You go sort of the extrajudicial route. But in fact, in 2008, when they began this, a Chevron spokesperson gave an interview to Newsweek, and when it was asked by the reporter why they were doing this, his answer, I think, speaks to their entire strategy, which was, we can't let little countries like Ecuador mess around with big companies like Chevron.
So, I mean, now that the tactic then, so Chevron doesn't have any assets really in Ecuador, so now we have these actions in other countries. And we have this ruling in Argentina, Andrew, based on the Inter-American Convention on the Execution of Preventative Measures. So I mean, what exactly does that mean? And will Argentina, or is Argentina coming under similar pressure perhaps then, as a result of the ruling to seize to at least freeze the assets in Argentina?
Yeah, well, I mean, obviously Chevron is going to leverage their considerable resources to make sure that doesn't move forward, and they've essentially appealed the ruling, and so that's what we're waiting to hear from. And there's
a lot of cooperation between the Argentinian government and Chevron.
They've signed a memorandum of understanding for future work, et cetera. So
you wonder how all these things factor in. Perhaps.
Well, I think Chevron, as far as I understand, they're essentially threatening to kind of pull out, which is not what the judge's ruling is. I mean, essentially Chevron needs to continue operating there, and some of their, not all of, but some of their profits that they're making need to go towards the Ecuadorians. But they're threatening to pull out, which is kind of curious. I mean. Argentina is one country. Graham can talk about the enforcement actions that have been filed in Canada and Brazil. Chevron has assets in most of the countries around the world,
right.
And essentially the rainforest communities have the right now to go to any of those places and to file enforcement actions.
Let's go to Canada then. So this Thursday, I believe then, Andrew, you're filing suit. What exactly are you going to be arguing?
Well, we actually filed a recognition action in Canada at the end of May. Canada was the first country that the Ecuadorians filed an enforcement action in because they wanted to show how confident we are in our judgment that a country that has just a sterling reputation for the independence of its judiciary would recognize this judgment, and that's exactly what we believe will happen. Chevron has filed a motion to say that the court in Canada doesn't have jurisdiction to even hear this action. And so that's what's being argued this week in Canada.
But also that even if the case was heard, these are Canadian affiliates that you're trying to get money from, and they're independent and indirect, and they have no connection to Ecuador.
Right. Right, that's Chevron's argument. We've actually filed against both Chevron Corporation, the parent, and their Canadian subsidiaries. And we found through discovery that really Chevron operates entirely through its subsidiaries. It doesn't have any assets Chevron Corporation doesn't even own the building it operates out of in San Ramon, California. And so it is entirely dependent on its subsidiaries, and it entirely directs and controls all of its subsidiaries for all upstream and downstream production. So they're trying to argue that their subsidiaries are entirely separate. But the fact is, if that was true, that Chevron would be completely bankrupt because they have no other way of making money other than to direct and get the proceeds and dividends and profits from their subsidiaries.
There's also,
so we believe that we're in a
I mean, sorry, just to hurry along, we've only got about 4 minutes left, I think. There's also this RICO lawsuit, though, the Racketeering, Influence and Corrupt Organizations Act, which was used, against the mafia, basically, which Chevron have brought against you.
Yeah.
And then, of course, there's arbitration in The Hague going on as well. I mean, won't these have a bearing on the sort of judgments that are going on in Canada and Argentina, perhaps, though?
We don't believe so. The fact is this RICO complaint is just another sideshow and part of Chevron's ongoing campaign to really intimidate anybody who has anything to do with this judgment. I mean, just last week, they filed an ethics complaint against the head of the New York State pension system because he had the guts to stand up to this company and say they should do the right thing and settle this case.
Right, well, that was an interesting thing.
They've subpoenaed interns on the case. I mean, this company is writing the book on how to try to intimidate and bully your way out of paying a big judgment. The problem is the more forms they try and the more ways they do, they keep failing. And in fact, as we saw in Argentina, not only are they failing to intimidate us, they're now having their own assets seized.
I mean, actually, the one other tactic which we just heard of was then they're attempting to get email accounts details from email providers for activists and journalists and attorneys.
Yeah, Google, Microsoft, and Yahoo. Yeah.
Okay. Tyson, then, to bring you back in. I mean, what was also interesting there then was the role of shareholders in this case, actually. The New York State Comptroller, who oversees about $800 million of Chevron stocks, said, hang on, they should settle this and sort it out, and the CEO is in the wrong. I mean, that's an interesting component of this as well. Are shareholders are getting involved in this?
There are, and shareholder activism has a mixed record in the United States because it's often very difficult for a minority of shareholders to build enough momentum to get full approval for their resolutions at shareholder meetings. There's another interesting component. As part of the Dodd-Frank Financial Services Reform Act that passed the United States Congress in 2010, the U.S. Securities and Exchange Commission has rules that will require oil companies and other extractive companies to report any payments that they make to foreign governments, typically bribes, in excess of $100,000.
Now, in this case, has there been any allegation of that?
There isn't, but I think that one of the things that we need to learn from this case is that we need to have greater transparency and codes of ethics for oil companies. And one of the first and easiest things we can do is just make sure that they come clean about bribery payments that they make to some of these other countries. And then next, either through shareholder actions or through other activities, we can try to have a better moral and ethics code that these corporations have to operate under.
But it was notable that the American Petroleum Institute has put in a lawsuit or filed a lawsuit to block that Dodd-Frank
That's right.
provision. Did they say why? I mean, doesn't it look a bit fishy?
The spokesperson for the American Petroleum Institute, which is the primary lobbying arm of big oil in the United States, Jack Gerard, when they announced that lawsuit, he said, it's not fair that publicly traded companies are going to have to abide by a higher standard than state-owned oil companies. So basically, what the American Petroleum Institute said is, we want to have a race to the bottom in terms of morals and ethics. If other countries get to cheat, well then, we should too. And that is not the kind of lesson that we have to learn from the disaster in Ecuador.
Tyson, we literally only have 30 seconds, but what are the implications of this case? How does it reflect what's going on elsewhere in the world as people try and seek justice for environmental pollution? And so on?
This is huge. I mean, this is a bellwether case about whether or not indigenous communities and other communities can successfully do a David versus Goliath battle and go against these multinational corporations. It is important that multinational corporations operating anywhere with headquarters in any country be held accountable for their crimes and their actions.
Tyson Slocum, thank you very much. Andrew Miller, thank you. Graham Irian, thank you very much as well. And that's it from the team in Washington, D.C. for now. Don't forget to follow us on Twitter and Facebook, where you can find more information about the program. And we want to hear from you. Tell us what stories you think we should be covering. Send your ideas directly to us at InsideStory@aljazeera.net.